I have said time and time again, even before the 2020 election, I would vote for a half-dead goat before voting for Trump. And the Republicans, the Christo-fascist Project 2025, and this year's Supreme Court session, it really solidifies the fact that I would vote for a half-dead goat if it had a D behind it. I would vote for a slightly moldy ham sandwich, and I don't eat ham and I don't eat moldy food before I vote for Donald Trump. And it's because of the Supreme Court in its conservative leanings, extreme conservative leanings, that I say this, plus Project 2025 and how they're really trying to take women into the Handmaid's Tale. This is an amazing rundown from The Guardian about the court's decisions. Let's get into it. The U.S. Supreme Court has wrapped up its 2023-2024 term, issuing a string of blockbuster decisions with enormous implications for American democracy, individual and civil rights, and the basic functioning of the federal government. Once again, the conservative supermajority, with half of its justices appointed by Donald Trump, was in the driver's seat, strengthening the power of the presidency in its immunity ruling for Trump and overturning precedent in a dramatic blow to the administrative state. There were crumbs of comfort for liberals, including a Pew Pew rights ruling related to DV and a unanimous decision upholding access to a key smemortion pill. But what the U.S. public increasingly sees as an activist court majority continues in full swing. In the most controversial cases, the conservative justices voted more often with the majority. And like I said, this is a great article because of the graphics. It really puts things in full view of how these people voted. Most of the session's biggest cases were decided by a 6-3 majority, but not always along ideological lines. So you can see the vote counts here. Yesterday's ruling was very disheartening, where they ruled Trump has absolute immunity for official acts, ruling that this man could get away with anything if he's acting like it's in the official capacity of president. This is ridiculous because this says that these people are basically kings and get held to a different standard. And this is what this conservative Supreme Court ruling did. And you can see that they all voted along ideological lines. The U.S. Supreme Court ruled in Trump v. United States that former presidents are entitled to some degree of immunity from criminal prosecution, dramatically reducing the likelihood that the federal criminal case against Donald Trump on charges he plotted to stop the transfer of power will proceed before the 2024 election. The court's conservative majority, which Trump helped create, found that presidents are protected from prosecution for official actions that extend to outer perimeter of the office, but could face charges for conduct undertaken in personal or private manners. The court strikes down a 40-year precedent, reducing the power of federal agencies, also along ideological lines. And this is strengthening corporations and deregulation, letting them do whatever the heck they feel like. The court overturned one of its own most important precedents, the Chevron Doctrine, that for the past 40 years has guided the work for federal government in critical areas of public life, from food and drug safety to environmental protection. In a ruling in 2 cases, Loper Bright Enterprises v. Raimondo and Relentless v. Department of Commerce, that the Biden administration warned could have a convulsive impact on the functioning of government, the court's hardline conservative majority voted as a block to throw out the Supreme Court's own 1984 opinion in Chevron USA Inc. v. Natural Resources Defense Council. That decision required the courts to defer to the knowledge of government experts in their reasonable interpretation of ambiguous laws. It has long been a target of the conservative legal movement. It does not want experts to be able to make experts' decisions and challenges to these companies. They want to be able to do whatever they feel like at the detriment to us little people that have very little recourse when it comes to their money and their power. And now, obviously, the Supreme Court. Decision to narrow obstruction law could affect prosecutions of January 6th rioters and Trump. And my WTF moment was Justice Jackson. Like, literally, why are you voting with these people? The court narrowed the statute that prosecutors have relied on in the cases of hundreds of rioters that took part in the January 6th Capitol attack for obstruction of an official proceeding, a ruling with profound implications for participants on that day in 2021. The 6-3 ruling in Fisher v. United States could also affect the federal criminal case against Donald Trump, who is charged with similar offenses in special counsel Jack Smith's investigation into the assault. The decision stems from the conviction of Joseph Fisher, a former Pennsylvania police officer who took part in Trump's so-called Stop the Steal rally on the morning of January 6th before then entering the Capitol with the mob, this supposed peaceful mob that was just going there to just talk and maybe look around the Capitol or whatnot. And then they got a little rowdy, I guess. This whole case got a WTF for me. Unhoused people sleeping outside can be fined and jailed. If they are homeless, what money are they going to use to pay for these fines, number one? And number two, taxpayers are going to be on the hook for providing the meals and the housing and everything in prison. But this is probably going to lead to a different variety of slave labor or, different labor type of things where they're using these people once again in chattel type of situations. So that is probably where these conservative judges are going with this, considering so many people are opting out of having babies and the birth rate is tumbling to hell. So that is probably the whole point, is just to create some workers, I guess. I mean, I don't really know. The court ruled that cities in the U.S. West can criminalize unhoused people for sleeping outside, even when they lack access to shelter. The ruling is a victory for Grants Pass, Oregon, which for years has prohibited sleeping and camping in its public parks and on its streets, banning unhoused people from using a blanket, pillow, or cardboard box for protection from the elements. The city's policies call for a $295 fine and criminal prosecution, punishable by up to 30 days in jail after multiple offenses. In City of Grants Pass v. Johnson, the court ruled 6-3 that it is not cruel and unusual punishment under the 8th Amendment to ban unhoused people from camping outside when they have nowhere else to go. The decision stands to broadly affect how American cities approach homelessness and could lead to more jurisdictions passing laws to ticket, fine, and jail people for living outside, marking a significant erosion of unhoused people's rights. So this is going to be jacked up, considering many people's wages are not keeping up with the cost of housing and inflation and everything. So this is going to harm lots of people, I believe, but we shall see. Court allows emergency abortions in Idaho for now. The fact that the state of Idaho went to court for their rights to let pregnant women die versus giving them emergency saving care is wild to me. And it's wild that women haven't just left in protest, but that's where we are in these forced birther states. And this is another reason why I will vote for a half-dead goat before voting for Trump, because WTF. But regardless, this one passed, and for now, pregnant women can get some reprieve in Idaho. I've actually done this article before, so I'm going to jump to the next one. Court blocks EPA attempt to reduce pollution that drifts across states, because this court is also pro-pollution. Pro-pollution, that's what this court is. Of course it is. The court put a hold on an attempt by the EPA to reduce harmful air pollution that drifts across state lines. The ruling in Ohio v. EPA sided with 3 states, Ohio, West Virginia, and Indiana, and industry allies seeking to derail so-called good neighbor regulations, which prevent pollution from billowing into neighboring states. The program, first drawn up by the EPA in 2015, is designed to prevent upwind states from causing air pollution that that flows to downwind neighbors. The primary target of the regulation is ground level ozone, which forms smog that causes an array of health problems. The case will continue to play out in lower courts. This article is pretty long, so I think I'm going to do a part 2. Stay tuned. So this is part 2 of the Guardian's write-up. So this ruling was mixed. Justice Jackson voted with the majority, and Kavanaugh and Roberts did not. Decision blocks Purdue Pharma bankruptcy settlement that would shield the Sacklers from lawsuits. In Harrington v. Purdue Pharma, the court rejected painkiller maker Purdue Pharma's bankruptcy settlement plan that included an extraordinary measure to protect its Sackler family owners from further liability over the American opioid epidemic in exchange for providing funds for compensation and rehabilitation treatment. The deal was constructed to allow Purdue, the Connecticut company behind the prescription opioid OxyContin, to restructure and also shield the relevant Sackler billionaires without them having to declare personal bankruptcy. The family agreed to contribute $6 billion to the settlement from the vast fortune they made from OxyContin and give up ownership. The company wanted to use the bankruptcy agreement to resolve thousands of lawsuits, many filed by state and local governments across the U.S., alleging that Purdue Pharma fueled a crisis that ultimately took out 500,000 Americans by claiming its flagship drug was non-addictive while incentivizing massive overprescribing. Now, to this case, the SEC's in-house rulings violate U.S. Constitution, obviously all conservative. The court stripped the SEC of a major tool in fighting securities fraud in a decision that could have far-reaching effects on other regulatory agencies. The justices ruled in a 6-3 vote that the SEC the SEC v. Jarski, that people accused of fraud by the SEC, which regulates security markets, have the right to a jury trial in federal court. The in-house proceedings the SEC has used in some civil fraud complaints violate the Constitution. That's what the court said. So this next case is a mixed bag. Government is allowed to request removal of misinformation on social media. It's 6-3, but all 3 liberals voted for this and 3 of the conservatives voted for this one. The court struck down a lower court ruling in the case of Murthy versus Missouri in a decision that did not find that the government's communication with social media platforms about COVID-19 misinformation violated the First Amendment. The decision permits the government to call on tech companies to remove falsehoods, a key concern as misinformation spreads around this year's presidential election. The court ruled 6-3 that the plaintiffs had no standing to bring the case against the Biden administration, with conservative justices Samuel Alito, Clarence Thomas, and Neil Gorsuch dissenting, although many of the arguments in the case centered on how governments and platforms interact with free speech online. The ruling focused more on procedural issues and lack of legal grounds to bring the case. This next case, which should have been 9-0, that people who have committed DV shouldn't be allowed to get pew-pews, and the only person that dissented is Clarence Thomas. This should have been a no-brainer. Why should abusers get to have pew-pews? Who knows? I'm not going to deep dive into this because it's still that abusers cannot get pew-pews. That is constitutional. It is fine to make sure that these people should not have pew-pews. But another pew-pew decision. Federal ban on bump stock devices for pew-pews struck down. And all I could say was, the court struck down a federal ban on bump stocks, the devices that can vamp up semi-automatic firearms to discharge ammunition almost as rapidly as machine pew-pews, and that have been behind some of the most devastating mass pew-pewings in recent history. The ruling in Garland v. Cargill was 6-3, with the court's liberal justices dissenting from the conservative majority decision. Writing for the majority, Justice Clarence Thomas said that a semi-automatic firearm equipped with a bump stock did not meet the definition of a Machine pew pew. Machine pew pews are subject to stricter regulation. We've already talked about this one, but this one was a 9-0 situation where the smemortion pill still remains. People can still get this. The forced birthers were trying to get this one pushed through so women wouldn't have access to this pill, as forced birthers are still trying to strip women's rights. This one got a grrr from me. South Carolina doesn't need to redraw congressional maps to consider Black voters. The fact that so many of these Republican states are gerrymandered to hell basically silences non-white voters and their votes. This is the reason why so many states are Republican or in the red category, because gerrymandering is a real thing. The courts ruled that South Carolina Republicans do not need to redraw their congressional map, deciding that a lower court had not properly evaluated the evidence when it ruled that lawmakers had discriminated against Black voters. In a 6-3 decision, the justices sent the case back to a lower court for further consideration. The ruling in Alexander v. South Carolina Conference of the NAACP is a major win for Republicans, who hold a slim margin in the U.S. House with 6 of South Carolina's 7 congressional seats. It also could give lawmakers more leeway to discriminate in redistricting and use partisanship as a proxy for race. That could be enormously powerful in the U.S. South, where voting is often racially polarized. And that's where we're going to end that. So what have we learned? They are pro gerrymandering. They are these conservative justices are pro pollution. They are pro having a king for a president. They are pro just stripping the rights of the little people and giving more and more and more rights to these corporations. And this is the reason why I will be voting blue no matter who. I will be voting for a sandwich, a moldy sandwich at that, if it has a D behind its name, Project 2025, and the fact that 2 Supreme Courts could be up for grabs this election cycle is another reason why, because these people are coming after DEI, that's diversity, equity, and inclusion. They're coming for women's rights. Obviously, I mean, they have been doing that since the 80s with the moral majority, but there is nothing in no way that I could vote for these people. They are trying to create a theocracy. They're trying to make a dictatorship for Trump a reality, and I just can't do it. I see Trump, these Christo fascists, these forced birthers, as a real threat. All right. So, like I said, this article from The Guardian is very thorough. Let me know what you think about these. Don't forget to like, comment, and share.